New York also holds that when a defendant testifies, he waives his Fifth Amendment right as to any topic relevant to guilt or innocence. In this case, if the defendant testifies as to his mental state at the time of the crime, he will have waived his Fifth Amendment rights on this issue. Also, it should be noted that even if the court had not ordered the examination, the people could have had a mental health expert sit in the courtroom while the defendant testified, cross-examined the defendant as to questions relevant to the expert's opinion, and then could have called the expert to testify. Thus, the examination could be conducted in front of the jury. In contrast, when the court grants the people a pretrial examination, the government's expert, after completing the examination, must submit a report to the prosecution and defense counsel. Defense counsel will then be aware of the expert's opinion and can make a more intelligent decision as to how to proceed and how to present his EED defense. The court finds that the court-ordered examination was constitutional and did not violate defendant's right against self-incrimination. The expert's testimony will only be admitted after the defendant has, in fact, waived his Fifth Amendment right by testifying to a mental state or to a fact from which the jury can infer a mental state defense. CPL 60.55 is limited to defendants who claim insanity and does not apply to other mental state defenses. People versus Angelo, 88 New York 2nd, 217. 222, 1996. Thus, from a statutory perspective, there is no bar to using the defendant's statement made to a psychiatrist if the defense is other than insanity. In People versus Cobo, the Appellate Division First Department held that a defendant who presented a battered spouse syndrome defense was properly impeached by his statement to the government's psychologist. The court did not discuss the Fifth Amendment problem of the statement that the expert's testimony is limited to the mental state and to no other purpose. In this regard, it is observed that statements taken in violation of the Fifth Amendment may be used against a defendant for impeachment purposes, provided that they were not coerced. New Jersey versus Potash, 440 U.S. 450, 458 to 459, 1979. Harris versus New York, 401 U.S. 222, 1971. The issue then is whether a court-ordered examination is coercion, such as to preclude cross-examination on statements given to an expert. In People versus Jackson, 244 Appellate Division 2nd, 757, 758, 1997, the Appellate Division 3rd Department reiterated the long-standing rule that when a criminal defendant places his mental state in issue, whether by an insanity defense or otherwise, the people's expert is limited to testifying to the mental state issue and no other, citing Lee. Jurisdictionally speaking, outside of New York, jurisdictions have ruled that any use of the information obtained by the government's expert from the defendant, other than on the mental state issue, violates the Fifth Amendment.
My paper gave out halfway through. I mean, it was good. It was good.
It was 140.